Yeah, please settle status.
Good evening, everyone. Welcome once again to Legal Time with Connaughts. As you can see, we have Sharia Khan with us today, our head of immigration, after a short break. Welcome, Sharia.
Good evening. Thank you so much.
So today we've decided to discuss a category that is not very common in immigration. It's called representative of an overseas business. So we'll discuss that category. We cannot take live questions today, unfortunately. We will also go through some recent case laws as well to update you on different issues. For example, there's a recent case law, a recent development when it comes to TOEIC cases, and there are some other developments when it comes to long residence cases. So we'll be asking Sharia to shed some light on those recent case laws as well. So Sharia, starting with representative of an overseas business.
Yes, well, this is a category which is not too popular, but it's becoming more and more popular as the tier 1 entrepreneur keeps on getting tougher and tougher to satisfy the requirements of. So the core requirement of that route is that there must be an overseas organization. So there are two categories within this visa category, and the first is that if somebody is a representative of an overseas media organization, or let's say a newspaper company or a media company like BBC, CNN, or even smaller ones. And alternatively, the second one is, which is that you're simply representing an overseas business which has a commercial presence overseas, and they wish to open a branch office or a representative office in the UK. So example could be that if you have a business in Pakistan, for example, and you have a senior employee who you wish to send to the UK to open a representative office, then you can use this category as opposed to using the entrepreneur category. And we would encourage that in a case where a company has an overseas presence, because number one, the statistics are very good, the success rate is very high in comparison to tier 1. Number two, there's no minimum requirement of having £200,000 set for 90 days. It's just a question of you demonstrating where you're going to open your offices, how many people you will employ, and as long as you have the funds or your company has the funds to justify that, that's fine as well. So again, in an entrepreneur application, an applicant has to show the funds in their own personal account for 3 months. The benefit in this one is that the funds could be lying in a company account, and that company, similar to a third party, but third party gets very technical and difficult in tier 1. But in this one, it's very easy to satisfy the requirement, and that company says, we're sending our director to open a branch office in the UK. So that particular person, along with their whole family, can migrate to the UK on this visa. And the English language requirement is of a lower level as well. And again, then there's no maintenance requirement of having £3,300 odd and then additional funds for dependents, but rather that you just simply need to show that you're able to maintain and accommodate yourself. So what we would suggest to people is that if you're blindly just making a tier 1 application because you want to move to the UK, also consider this route, also speak to us, speak to lawyers about this route, and if you are able to apply under this category, you should use this.
Excellent. And good thing is, if you are an employee of an overseas business, there's no specific time limit in which you have to be working for that employer. So as long as you can justify that you know the business very well, you can obviously qualify under this category.
Correct.
Family can apply, as you said.
Family can apply. I mean, the of course, as we get deeper into this route, there is a requirement that you must not be a owner yourself or a majority shareholder. So if you have your own business abroad, yeah, exactly, you can't send yourself across to the UK. But yes, of course, you can send any senior manager, any director, and even minority shareholders. As I said, even 49% could technically work, but the idea really is that you shouldn't really be controlling the company, but you must be at a senior position of the company abroad.
Excellent. And when it comes to the duration of stay, initially they get 3 years.
Correct.
And after 3 years, they will have to demonstrate that they continued the business in the interest of the company. They have to show 12 months worth of wage slips showing that they have received salaries in the past 12 months from the company, and then they can apply for an extension meeting certain other criteria, which include certification from the company confirming that the company still requires their services, and then you get an additional 2 years.
Additional 2 years, and then similar to all other routes, after completing 5 years, you get indefinite leave.
Excellent. So anything else you want to add in this category? Because it looks like a very lucrative, attractive category, and it's been there for a while. And
it's been there for a while, and us together, we've been using this category quite often for the last few years. But we keep on encouraging through these social media platforms for applicants to just not blindly apply for other routes just because they're more popular, because you might meet the requirements of, in this case, requirements of sole representative. So I guess we can really advise truly and in more detail as you email us, as you contact us. But that's something to consider.
Excellent. And Sharia, again, TOEIC, it's something, I mean, no program can go without discussing TOEIC matters, because there are quite a lot of them. So recently, you have received a lot of consent orders from on your matters. I have received few where now Home Office is settling these matters. And they are also giving right of appeals or allowing applicants by issuing Section 120 notice to make further representations, human rights claims, so that if application is further refused, the right of appeal can be given to them.
Yes.
That is for those who were refused under the new type of Section 10 decisions where they did not have right of appeal under point-based system.
Yes.
So your view as to what exactly these applicants needs to do now?
Well, again, it's a question of if you were affected by the ETS, by the TOEIC tests and your applications, or your visas were curtailed, then you should see professionals. Don't believe just because you lost a case a couple of years ago that it was the end of the matter. Cases that Wes and I were involved in that were going on since 2016, 2015 are now all being reconsidered. When I say all, of course, they have their own specific facts, but at least cases which were in the Court of Appeal, the Home Office have actually agreed that if they are now going to give us a right of appeal and the client is able to show that they've actually not employed deception, then the Home Office is going to go back and reinstate their visa from 2 years, 3 years, 4 years. And what we see is that if our client happens to have been legal for the last 3 years, 4 years, most of the applicants have been in the country for 10 years. So, it could be, it's a question of being lazy in some cases, because we've got clients who've got children and they just say, okay, fine, we're just going to apply under the 276 AD or the 7-year rule, and we're just going to get a 2.5-year visa. But if you think about it, if you give this some time, effort at this stage, then you could end up with indefinite leave for yourself and your family because your visa was unlawfully cancelled, whatever, 3 or 4 years ago. Whereas if applicants rely on the 7-year rule, then it's a question of getting a 2.5-year visa, which you have to renew 3 more times. So then you wait 10 years to get indefinite, then you pay loads of Home Office fee, which keeps on increasing every year. So it makes no sense why you would do that. It's a good question. It's like any serious illness. You should probably see a professional and just discuss your case thoroughly before deciding on these TOEIC matters.
Yeah, I mean, in a lot of consent orders, obviously, I would say that they have to speak to their lawyers to negotiate these consent orders with the Home Office, because a lot of them, Home Office is specifically mentioning or adding a clause in the consent order that if after exercising the right of appeal, tribunal decides that deception was not adopted by these applicants, then Home Office will put them back in the position they were before Section 10 was issued.
Exactly.
That, like you said, will put them in line with their long residence applications if there was obviously no gap before Section 10 was issued.
Yes.
So which means they will qualify under long residence if once they finish their 10 years. And a lot of them actually have already finished their 10 years just because of this TOEIC matter has been going on.
Most of these cases have been going on at least with us for 4 or 5 years, and applicants have been in that country before for 4 or 5 years. So I expect, again, even if it's not 10 years, you would have been here 9 years or 8 years. It's a question of just renewing your visa once. So definitely these consent orders are complex. For us lawyers, we have worked really hard to represent these ETS migrants who at the end of the day now have A, a right of appeal, and B, it appears they're being put back in the position they were. So it's a great success for, of course, all of us, and you should, of course, reap the benefits of it.
Excellent. And that brings us to our next question, 10 years long residence. We have discussed it in many of our previous videos, how the exception of Section 39E applies, or 276B subsection 5. How does that work? Now we have a recent case of Ahmed versus Secretary of State where court has laid down that you won't be able to use 10 years long residence unless you have finished 10 years long residence.
Correct. So it's a tragic decision. It's a tragedy, so to speak. But again, with these ETS cases, we've always seen that we face initially opposition from the judiciary, but if you keep on fighting a point properly, and we believe there's more to the point than what was discussed in the case of Ahmed, with of course all due respect to the judiciary and the decision, but I understand that decision itself is being appealed. But as Wes was saying, what the courts have recently decided is that you must actually complete a full lawful period of 10 years in the country. So if, for example, you have completed 9 years, 6 months, and then all your appeals or your application has been refused, and then you make a fresh application. So although if you make that fresh application within 14 days, the technicality is that you're not legal in the country after that period. So if that application then is lying with the Home Office and you complete 10 years, the Home Office can still refuse the application, saying that you've actually only been here 9 years, 6 months. The last 6 months have not been lawful. Now what we are trying to assert is that if an applicant makes an application within 14 days, and the Home Office within their rules, as Wes and I were discussing, have a clause which says that that period of overstaying will be overlooked, then the fact that that application was with the Home Office for 6 months should not be to the detriment of the client, and that application should actually be successful and that period should be considered lawful. Even if, of course, we're not saying that there should be 3C, it becomes difficult arguing that you have 3C leave in such a case, because that's by operation of a point of law. So it's like mathematics, so it has to be what the law itself says. But if we look at the guidance and look at the rules, then we think that the decision's against human rights, if nothing else, and that's why 39E, or at least the interpretation of these applications, should be in such a way that applicants should be considered to have been lawful for the whole period. So it gets technical if we explain it in this way, but if you're completing 10 years and you're unsure about what to do in the last few months, speak to us. I'm sure we should be able to find a solution.
Yes, I mean, like Sharia said, that decision of Ahmed itself has been challenged. We have applications pending in the higher courts on the same point of law. So if you have a similar type of case, you can contact your lawyers, you can contact our offices. I think at this stage, a better option would be if someone is, for example, in a judicial review process, to have these matters stayed until the permission decision comes from Ahmed or other cases we have.
Well, I would say yes, I would completely agree with that advice. But in addition, I think a lot of lawyers are approaching this point, even the way it's been considered in the case of Ahmed itself, it shouldn't be argued that there's 3C leave. It just needs to be approached in a different way, where you balance what the Home Office is saying against what the guidance is saying. And I think you can meet in the middle. I just think it's so far being argued in a very harsh way, and where applicants are simply saying, we have been here legally for 10 years just because we made an application within 14 days. That in itself may not work, but there's a technicality here which other barristers who have worked with us on these cases have also agreed that there are merits in the case still after the case of Ahmed. So it's a question of seeing professionals really and getting good advice on these points.
Yeah, excellent. I mean, we also have a lot of cases where people, they had gaps, previous gaps in their 10 years long residences, and then subsequent leave was granted, but gaps were more than 14 days, for example, so where they did not put in an application within 14 days, or previously like it was 28 days. Yes. In that case, also, long residence definition includes if you were given temporary admission in the UK, or you were granted bail under the new rules, and then subsequent leave was granted, even if it was long time after, that period should be considered as lawful residence in the UK. So there are a lot of technicalities when it comes to 10 years long residence. So just because you have a gap, do not think that you do not qualify. See an expert and get their opinion, get all the facts right, and then obviously you can make a decision, or they can make a decision for you.
I mean, on that point itself, sometimes what I'm also saying is that if your application has been refused without a right of appeal, and applicants have gone on to successfully judicially review that decision, the Home Office is still somehow maintaining that those applicants don't have 3C, which makes absolutely no sense, because if the original decision has been cancelled or withdrawn, then obviously they have 3C. So for example, I'm representing a client right now who is on a Tier 2 visa, and we've successfully gone for a judicial review and had his original decision now being reconsidered, but he's lost his job because the Home Office is informing his employer that he doesn't have right to work, he doesn't have 3C. So of course now this is the case which will go to court again, and he will be awarded damages because this person's been unlawfully removed from his employment as a consequence of what the Home Office is saying. So it's again a question of not following what the policy says, speaking to lawyers and getting true advice on that.
They use a particular phrase. They say once it's cancelled, it cannot be resurrected.
Exactly.
And which is very surprising, because it's almost like, yes, we have made a wrong decision on the application, we are willing to reconsider that application, but at the same time our wrong decision will have negative consequences for you.
So you will be an overstayer, but we made a mistake. That makes no sense. So their policy guidance on that point is not correct.
Excellent. And also good news for those, like we discussed in our previous videos, extended family members of EEA nationals. There was a right of appeal. Then we had case of Salah came in, right of appeal was cancelled. Then Salah was overruled. So under 2006, before 2016 regulations, and any applications that were made had right of appeal. But after 2016 regulations, there was no right of appeal. Now, after the case of Bangor, we know that Secretary of State has decided that they will be putting legislation in front of the Parliament, and as soon as Parliament has approved it, there will be a right of appeal for extended family members, as long as you can prove the relationship, of course. So it's a good news. We have had a lot of judicial reviews pending on this point, which have now been, Home Office has started reconsidering them. And so it's an excellent news for those extended family members who did not have right of appeal, had judicial review pendings, or about to make an application on those basis. Anything else you want to add or discuss, Sharia?
Well, a lot is happening, a lot of changes, and of course then we've got the new statement of changes coming. So we will be keeping up to date as to any changes which affect all migrants. On the 7-year rule as well, I would see that there are very odd decisions coming from the Home Office in some cases, where immigration judges might in the past have dismissed your case. So traditionally the advice would be that if a judge has refused your application under the 7-year rule, then you're not eligible really to make another application. But it appears that the Home Office is operating a different policy. Then they are looking at cases again afresh, although immigration judges have decided otherwise. So again, that might be potentially a shift in regime, or things looking positive from the immigration side these days. So if you've had an application under the 7-year rule refused, even by an immigration judge, speak to lawyers. There might be again something in making a fresh application to the Home Office.
Excellent. I think that is it for today, and that's what we had to discuss. And we will be bringing some more updates in 2 weeks' time, especially on changes in the Appendix EU and free movement rights, depending whether it's a deal or no deal.
Yes.
And so stay tuned. If you have any questions, please email us, text us. You can use our social media platforms. You can go to our website, and there's a lot of information available there for you to understand any recent updates, etc. So please feel free to contact us. In the meantime, take care of yourself, and we will see you very soon. Thank you.
Good evening.
Good evening. Bye-bye.